questions through the chat. Thank you. Questions through the chat function, please. I've just asked everyone to put their names just on their computers so I can just mark in attendance. So we're just recording who actually attended. And I think that's about it. So we are recording this this event. So thanks, Paul. I know your name's Paul Sweeney. So we'll get underway, and yeah, 6 o'clock. Thank you. Well, good evening, everyone, and welcome to another New South Wales Association of Fire Investigators Education Night. Tonight, we're really privileged to have Catherine Biber give us a presentation. Catherine is a legal scholar, criminologist, and historian. She researches evidence in different ways: photographic evidence, documentary evidence, criminal evidence, and histories evidence. She works at UTS, where she teaches the core law subject of evidence, and is interested in how evidence is used and misused during the legal processes, and how it was reused after the law's work is finished by journalists, artists, playwrights, and others. She is going to give a presentation on the expert witness, and that is very relevant to our industry, which is fire investigation. And as a fire investigator, you could be called up to give expert witness testimony in a trial. So this is very relevant and timely for our organisation to be given this presentation by Catherine. Welcome, Catherine, and thank you for your time.
Yeah, my pleasure. Thank you, Michael, and also thank you to Bob and Mark and the others involved in organising this. I don't think I've ever talked to a group of fire investigators before, so it's a little bit daunting, and also I want to be very clear that I don't know very much about fire investigation, and so I'm also here to learn from you. So look, it's 6 o'clock where I am, and my thought was, I mean, what I've done is what I always do, which is prepare about 50 hours worth of material, and I'm going to try and talk for about, let's say, 40 odd minutes so that there's some time for questions and discussion. Normally, if we were in a room together, I would ask you just to interrupt me as I go. But because I'm online and because I'm going to be sharing my screen, it's actually quite hard for me to see the chat and see if anyone's got their hand up. So
I'll monitor the chat. So if everyone wants to put their questions through the chat, and if you're happy, I can just interrupt you at as the chat or questions pop up. Are you happy for that?
I'm very happy for that.
Yeah, great.
But I'm also happy just to leave time at the end for questions that are not arising from something I specifically said. But if there are things I didn't say but you want me to talk more about, because it's called the expert witness, but this is actually a huge topic of knowledge and also a huge topic of controversy. So there is a lot to say, and I'm going to kind of do something kind of introductory and general for those of you who don't know anything, but also I understand some of you may know a lot, and I'd like there to be some value for those people as well. But there might be people in the middle who've missed something, and I'm happy to leave time at the end to do that. So,
yeah, I would just like to say that there's a vast range of experiences here. I would imagine that there are investigators here that have been doing this for a long time and have given evidence on numerous times, and you've got people here that have never done it. So it'll be very, very good for both to hear what you're saying. So thank you.
Great, thank you. And for those who do have a lot of experience, I'm also interested to hear from them about what are the evidentiary problems that you're facing or the procedural issues that you're facing, because I would like to learn, you know, from you, from this audience, what issues you have, what problems you have, what criticisms you have, so that we can all learn from each other.
Excellent.
Because in the area of expert evidence, this is one of the areas where there is, I would say, a failed dialogue between the legal profession and the scientific professionals. And so if we could do anything to improve that dialogue, that would be great. I'm sorry, I'm just going to sort out my blind because there's a bit of glare. That might be a bit better. All right, sorry, I'm sitting right in front of a window that's got the sun in it. All right, so I'm going to start. I'll share my screen and hopefully you can see that now. Are you all able to see my title slide there?
Yes, thank you.
Okay, so look, I don't want to pretend I know anything about fire investigation. A long time ago, I saw the film Backdraft. I thought that was pretty good. Then in 2012, the New South Wales Court of Criminal Appeal handed down the judgment in Gillam. Parts of that were about fire investigation. I read that judgment. I'll try and leave a bit of time today to talk about that case. Some of you may know it or have been involved in it. Some of you may not know, but would like to know about what the Court of Criminal Appeal did there. About a year ago, there was a fire in the apartment below mine, and there is still a dispute between the insurance company, the owners, and the tenants about what caused that fire. Since then, we've moved out of the building. That's pretty much the extent of my experience with fire investigation. So I would like to learn from you what types of questions arise for fire investigators when presenting evidence in legal proceedings. So my presentation is, as I've said, going to be quite general, but I want to hear questions and feedback. But also, if there's anything I say today that you'd like to know more about, I have a huge amount of resources that I'm willing to share. If I mention a case or if I mention some article that you think you'd like to read, just email me. I've got my email address on the last slide, and I will reply to you and share that material. So this is a huge field of knowledge. I'm just going to be very brief this evening, but I'm happy to share more knowledge if you have specific questions. So, sorry, just advancing. Okay, so these were the questions that I was asked to cover today. Well, some of them I offered and some I was asked to cover. And these are the basic big topics I'm going to try and do very, very quickly. Firstly, more generally, if we consider fire investigators as part of the discipline of forensic science, why is it important for forensic science to be good? What is the legal process for presenting evidence? For people with specialised knowledge, and that's what lawyers call experts. We don't use the word experts, we call them people with specialised knowledge. How do the rules of evidence apply? And then finally, and this is really a big debate rather than a question, why do the courts allow the legal profession to vet and select their own experts? Will it ever change? So I'm actually going to start with a history lesson. And this comes back to my question, why is it important for forensic science to be good? All right, so what you're looking at here is a picture of Lindy and Michael Chamberlain. Lindy Chamberlain is the victim of Australia's most notorious miscarriage of justice. In 1980, her 9.5-week-old baby Azaria was taken by a wild dingo from the family's tent during a camping trip at Uluru. But Lindy and Michael Chamberlain were tried and convicted of her murder. Following their conviction, Lindy Chamberlain was imprisoned, where she gave birth to another daughter who was separated from her several hours after she was born. After Lindy had served almost 3 years in prison, the chance discovery of an important piece of evidence prompted a royal commission inquiring into the convictions. The Chamberlains were later pardoned, exonerated, and compensated. Following 3 coronial inquests, each with different findings, a final coronial inquest in 2012, concluding on the day after Azaria's 32nd birthday, confirmed that Azaria was killed by a dingo. Although the fuller analysis is complex, the Chamberlains' wrongful conviction can be mostly explained by bad forensic science. I don't know much about whether forensic practitioners today reflect on the Chamberlain Royal Commission, but it seems to me like the most important place to start. It doesn't relate to fire investigation, but it does relate to the principles, processes, ethics, and responsibilities of people who have specialised knowledge, scientific experts. There were so many shonky scientists involved in the wrongful conviction of the Chamberlains. Some of them were globally eminent, some were simply out of their depth. There was supposed blood spatter in the car, the place where Azaria's throat had allegedly been cut. There was her jumpsuit and evidence of the damage done to it that was said not to have possibly been done by a dingo and could only have been done by her being stabbed by a pair of scissors. There was the supposed bloody adult-sized handprint on her jumpsuit. There was the prosecution. So the prosecution theory of the case was this. Azaria, a much-loved 9-week-old baby, had been put to bed in the tent beside her sleeping brother. Meanwhile, Lindy, Michael, and their other son had dinner at a barbecue area. The prosecution theory is that Lindy briefly absented herself from the barbecue, went to the tent, took Azaria to the car, slit her throat with nail scissors, and then stuffed her dead body into a camera bag. Later, Michael helped conceal the body. Azaria's bloody clothing was scattered nearby, or maybe it was folded neatly. There was no motive presented for this outrageous crime, but this completely garbage hypothesis was supported by all of the Crown's forensic scientists to the point that the jury accepted it beyond any reasonable doubt. I think it's important to mention at this time, this was an extremely high profile case in Australia. It was a media sensation, so everyone involved in it was receiving a lot of public attention. The Chamberlains did have forensic scientists supporting them, albeit they were volunteers acting with few resources. Because so much of the Crown's forensic work had resulted in the destruction of most of the forensic samples, there wasn't much available for the Chamberlains' forensic scientists to work with. What was there required them to have knowledge that was at that time not well known. The behaviour and abilities of wild dingoes, especially their teeth and jaws, the impact of extended time and desert heat upon tiny blood samples. Also, some of the evidence unfortunately relied upon misunderstandings of the Chamberlains' faith. They were Seventh-day Adventists, but the Crown tried to suggest this was akin to a satanic baby-killing cult. I won't blame the forensic scientists for that. The Chamberlains' final available avenue of appeal against their convictions was to the High Court of Australia. When the court dismissed their appeal, the Chamberlains had formally exhausted all of their avenues of appeal. It was after their failed appeal to the High Court that the Chamberlains, supported by a growing group of independent scientists, was able to conduct a substantial body of scientific testing relating to dingoes, to the underdash spray applied to their car, and to Azaria's clothing. Their testing considerably undermined the conclusions drawn by the Crown's scientific experts who had testified at their trial. There was a groundswell of support for the Chamberlains at the highest levels, and it wasn't gaining much traction. But in 1986, in early 1986, in an event that transformed Australians' confidence in their institutions of justice, Azaria's matinee jacket was found. At her trial in 1982, explaining the absence of dingo saliva from Azaria's jumpsuit, Lindy Chamberlain had testified, Azaria had on a white knitted marquee matinee jacket with pale lemon edging. The matinee jacket wasn't found until almost 4 years later. An English tourist, whilst attempting to climb Uluru, had died. His body wasn't recovered for 8 days, and when it was badly mutilated by dingoes. In the search for his missing bones, the matinee jacket was discovered, and there is conjecture that its discovery was going to be kept secret by Northern Territory officials. But on the 3rd of February 1986, Lindy's lawyer received a tip, and 3 days later, when it was shown to her, and this is the photo of her seeing it, she identified it as the one Azaria had been wearing when she was put to bed in the tent. So this is a photograph of Lindy in her prison uniform, looking at this piece of evidence that had been lost for many years. The following day, in a climate of considerable political hostility and media pressure, the Attorney General of the Northern Territory, Marshall Perrin, having sought advice from the Solicitor General, the Police Commissioner, the Administrator and the Executive Council, gave a press conference in which he announced Lindy's release from prison and his decision to open an inquiry into the case. By April 86, the Joint Commission of Inquiry was instituted, one reporting to the Northern Territory Government and one which was a Royal Commission called by the Governor-General of Australia. Justice Trevor Morling was appointed Commissioner and given wide-ranging inquisitorial powers to review the Chamberlain case, particularly doubts or questions about the safety of their convictions, and to locate and hear evidence and conduct further research and to make findings and recommendations. The Victorian Institute of Forensic Medicine was charged with conducting a thorough forensic scientific review of all of the surviving evidence. The Commission gave exhaustive attention to Azaria's clothing and the scientific examination to which it had been subjected previously. On the question of the matinee jacket, Commissioner Morling concluded, quote, "There is no reason to doubt that when Azaria disappeared, she was wearing the matinee jacket discovered in 1986. The jacket would have covered much of the jumpsuit worn by the child. The failure to detect dingo saliva on the jumpsuit is made more explicable than it was at the trial." Oh, sorry, that was what I just read. In his conclusions, he stated, in light of all the evidence, there are doubts as to the Chamberlain's guilt. I do not think any jury could properly convict them on the evidence as it now appears. The report of the Royal Commission was tabled in the Northern Territory House of Assembly on the 2nd of June 1987. On that day, the government granted a formal pardon to the Chamberlains. I've written a lot about what happened to the surviving evidence in the Chamberlain case and interviewed a lot of people, including Lindy Chamberlain-Creighton, as she is now, about it. Much of it is now in the National Museum of Australia in Canberra, much of this surviving evidence, where I've seen it and I've interviewed its curators there. The Chamberlain collection is comprised of 6 smaller collections. The first 5 collections were deposited by Lindy, and the 6th collection came from Michael Chamberlain. He's now passed away, and it includes the yellow Holden Torana, which the Chamberlains drove from Mount Isa to Uluru on their family camping holiday, and which had been taken for forensic examination and returned to them in pieces after the conclusion of the Royal Commission. Michael restored it until it looked like this, and eventually the museum acquired it. And if you look closely, you can see he gave it a special number plate, which says forensic. With important exceptions, most of the Chamberlain collection in the National Museum is not on display. The National Museum had an exhibition for many years called Eternity. It was part of their permanent exhibition, but it's recently closed, and it included this object. This object was on display. This is a very small piece of metal. It's about 1 inch across. It's a small piece of the underdash of the Chamberlain's car, which was subjected to forensic examination. You can see actually the way that you view it in the museum cabinet is through this magnifying glass. That's the large circle kind of in the center of this slide. The forensic pathologist who examined this item testified that she had found blood spatter consistent with Azaria's throat having been cut. So what you're looking at here is the notorious arterial spray of blood that was later discredited as one of the many evidentiary errors made in that case. The forensic scientists working for the subsequent Royal Commission found that this spray had been applied at the time the car was manufactured, and it did contain iron, but it did not come from blood. It was used as a form of sound insulation. So in the museum cabinet, visitors could see this crucial item of evidence that was used first to convict and later to acquit Lindy Chamberlain. So I'm just going to briefly show you some of the other objects that are on display, that are not on display, that belong to the National Museum, that come from the Lindy Chamberlain collection and the Michael Chamberlain collection. Because why should a nation collect these objects? Why is all of the evidence of bad forensic science kept in the National Museum? What use is the criminal evidence that wrongfully convicted Lindy Chamberlain? For Lindy Chamberlain herself, the dominant use of these sensitive garments and other items in the museum is a potential forensic use. She told me, quote, "If there's another dingo attack and there are accusations like in my case of what a dingo can and can't do, there is actually a reference that they can go to. In that way, this collection is extremely significant," unquote. She explained that one of the scientific difficulties that arose in her case was the lack of aged blood samples, which might demonstrate the effect upon blood of time and heat. For Lindy, her deposit of these evidentiary materials into a national collection remedied this lack for potential future scientific uses. She told me that this scientific afterlife is one of the reasons she wants this collection to survive. Under the conditions of her donation to the museum, these items must be made accessible for scientific purposes. Okay, so this is the jumpsuit. This is Azaria's jumpsuit, and it's held in the National Museum of Australia, and it will be available for forensic scientists who need access to it for scientific purposes. That is one of the requirements of Lindy's donation. But I also spoke to Jane Torpen, who worked as a forensic biologist at the Victorian Forensic Science Laboratory during the Royal Commission into the Chamberlain convictions. And she talked about the scientific need to preserve evidence beyond the conclusion of proceedings and explain the contemporary forensic practice in which most exhibits are destroyed and only the records of the results of scientific testing are preserved. So forensic scientists might take photographs of their process and then destroy the actual original materials and only preserve the results or the photographs of their scientific processes. So in Jane Torpen's view, it was the survival of these items that guaranteed for the Chamberlains a pathway to justice. Torpen asked rhetorically, if there was no car and there was no jumpsuit, what would the Chamberlain Royal Commission have done? I don't think there would have been one, unquote. But reflecting on her own career and the myriad instances of bad, sloppy, shonky forensic science she had witnessed since the wrongful conviction of the Chamberlains, she asked herself, how do we remember cases like the Chamberlain Royal Commission? Would a jumpsuit do that? It certainly hasn't done it so far in my experience. Having that jumpsuit preserved in a museum hasn't impacted one iota the practices of forensic science, unquote. So the Chamberlain's conviction was a miscarriage of justice. Hopefully these are rare, but it's an important reminder of the consequences of getting things wrong and a good opportunity to talk about how we can do things better. I'm going to set out now the rules of evidence, or some of the rules of evidence, but I also want to leave time to talk about how even when the rules are followed, bad outcomes can still occur. Because in the dialogue between law and science, a lot of the time we seem to be talking at cross purposes. And so that's what brings me to talk about the rules of evidence and some of the underlying presumptions. So I'm going to start by talking about proof and presumptions, because evidence is the law's epistemology. It's about how the law comes to know things. Lawyers call this fact-finding. Another term is resolving disputed facts. The fact finder in legal proceedings will be the jury if there is a jury, and if there is not a jury, the fact finder is the judge. What we have is an adversarial system of justice. It means two parties engage in an argument or a fight about the facts. There are agreed rules to the fight. These are the rules of evidence, and the fight is presided over by an impartial judge. These are essentially two stories at war with each other. I didn't do it. Yes, you did. At the conclusion of the fight, the facts are found and a judgment is entered. It's important to state the conclusion of legal proceedings is not in any epistemological or ontological sense the truth. If you want to know the truth, you could speak to a priest or an astronomer or a philosopher or some other type of person. You don't talk to a lawyer. At the conclusion of legal proceedings, the name for what we arrive at is what has been proven. Proven using admissible evidence. So it's very important to know that the legal process is not a truth-finding process. It's a process of fact-finding and proof. So if you're looking for the truth, you actually just need to lower your standards. That's not what the law can offer. What the law offers is what can be proven using admissible evidence. So let's start with proof. Because proof refers to the fact-finding process in litigation. Particularly, parties have an onus or burden of proving certain elements of a case, and they need to fulfill that onus or burden to a particular standard. So as a general rule, the party who bears the burden of proof is the party who started the proceedings, and they are required to meet the standard of proof. So the party who brings or prosecutes a matter has to adduce sufficient evidence to meet the standard. The other party, if they choose not to, doesn't really have to do anything at all. So who bears the burden of proof? In civil cases, the plaintiff bears the burden. That's because the plaintiff brought the matter. They started the matter. In a criminal case, the fundamental principle is that the Crown has to prove the case. There are exceptions to all of these things, and if you want to know all of those, you can enroll in my evidence course. So what is the standard of proof? The burden of proof refers to the obligation on a party to prove facts. They have to prove facts to a particular standard. The standard of proof refers to the quantum of proof, or how high a standard they are seeking to meet. So as you're probably aware, and as the Uniform Evidence Acts now state, there are two standards of proof. In civil proceedings, the standard is on the balance of probabilities, and in criminal proceedings, it's beyond any reasonable doubt. Of course, both of these phrases are highly subjective. We have a whole lecture on what these words mean, but there is strong resistance to giving them any objective meaning. The law basically says these words are given their ordinary natural meaning. The balance of probabilities is what an ordinary person understands it to mean. It's not a special legal balance. And beyond any reasonable doubt also has an ordinary or natural meaning. It's not a special legal term. Okay, so what we have in New South Wales, and I know that you're the New South Wales Association, but I heard earlier that there are people from elsewhere that are present. So maybe I'll just clarify this. In New South Wales and at Commonwealth level, we have what are called uniform evidence laws. Those uniform evidence, that word uniform is aspirational. We do not have uniform evidence laws across Australia, but we do have other jurisdictions that have joined the uniform evidence regime. So as well as the New South Wales and Commonwealth courts, we also have Victoria, Tasmania, the ACT, the Northern Territory, Norfolk Island, although actually Norfolk Island no longer has self-government. Those are the uniform evidence regimes. So if you are practicing in any of those jurisdictions, you'll be subject to the uniform evidence laws, which I'm going to talk about today. If you are in Queensland, West Australia, South Australia, what I say will not be exactly correct. Okay, there is a long history to the background of the Uniform Evidence Act, and as I've said in summary, the idea for having uniform acts remains aspirational. It's important also to say that there are some differences of interpretation between the different courts within the uniform evidence regime. So what the New South Wales courts say about a particular provision may be a bit different to what the Victorian courts say about a particular provision. So that's just because lawyers like to be difficult and confusing, but I won't bore you with all the details of that this evening. But this long, complicated diagram summarizes the entire process of admissibility. So if you look at the top, you're asking, is a piece of evidence relevant? There's a legal definition of all the words I'm about to say. But if evidence is not relevant, you'll look on the right-hand side, it's not admissible, that's the end of it. If it's relevant, it goes further. You'll see it just goes to the next step, but it's not until the very, very final step that a piece of evidence is admissible. So we ask firstly, is it relevant? If so, it goes further. Then we ask, does the hearsay rule apply? Because hearsay evidence is inadmissible unless there's an exception to the hearsay rule. And if you get an exception to the hearsay rule, your evidence is not admissible, but it goes one further step. Does the opinion rule apply? And actually the opinion rule is where we're going to focus on our attention today, because when people with specialized knowledge give evidence, they give evidence of their opinion. So we'll come back to the opinion rule later. I'm just showing you the whole of the scheme, because opinions are inadmissible unless you get an exception to the rule. Evidence about previous judgments and convictions are inadmissible unless you get an exception. Does the tendency or coincidence rule apply? That's a special kind of evidence of similar facts where someone might have a tendency to act in a particular way, or similarities could not possibly be a coincidence. There's rules about that. There's a rule about credibility evidence that relates to the credibility of a witness who gives evidence. Credibility may also operate if you are giving evidence as an expert, for example, your credibility may come into issue. So make sure you are a credible witness, because there is a threshold for testing your credibility when you're a witness. There are special rules about identification evidence. There are special rules that apply when evidence will not be given because it's privileged. Privilege operates where evidence is not disclosed because there is some special relationship that preserves confidences and prevents evidence from needing to be given. So there is a privilege between a person and their lawyer. There might be a privilege between a person and their medical practitioner. There might be a privilege between a person and their tax advisor. So privilege might apply where otherwise admissible evidence is not admissible because it arose in the context of an important relationship, that because it is special, we say it is privileged. Sometimes evidence might be otherwise admissible, but in this second last box, a discretion is exercised to exclude it for some other reason. There might be some problem with evidence that is otherwise admissible, and it is excluded at this second last hurdle. If evidence is not excluded in any of these hurdles, it is admissible. That means it is admitted into evidence. That means it is before the fact finder. It does not make the evidence accepted. It doesn't mean the evidence is believed. It just means it is in consideration. It is up to the fact finder to decide whether they believe that evidence. So all of the rules of evidence are just about the admissibility of the evidence, whether it can go before the fact finder. Once the evidence is before the fact finder, it's up to that person, whether it's a judge or the body of the jury, to decide whether they believe the evidence. So we are not dealing with that part of the process. We're only dealing with what evidence is admitted. So this is the broad schema of the Act. So I said we're going to focus on opinions because people with specialized knowledge or experts, when they give their evidence of their opinion. All right. So we have evidence of opinions. There is supposed to be a distinction between a fact and an opinion, but the law acknowledges that a fact and an opinion exist somewhere on a spectrum. There are some things that are clearly facts. You know, this evidence that, you know, something might be exactly 5 minutes long, that's a matter of fact. Whether it's interesting or boring is a matter of opinion. And some things are somewhere in between that spectrum. But the opinion rule excludes evidence of a witness's opinion if it's tended to prove a fact about which the opinion was expressed. I'll show you the rule in a minute. This is very legalistic language. The general scheme of the Act is we only want to admit evidence of facts. Somebody's opinion about a fact is not admissible. We only want evidence of facts. And someone's opinion about a fact is not admissible. But there are going to be exceptions to that rule, and people who have specialized knowledge, which forms the basis of their opinion about the fact, might get an exception to the rule. So I could talk much more, but I won't, about the difference between a fact and an opinion. I'll just for now leave it with this idea of a spectrum. But for people like you will be going into, for example, a scene of a fire, examining data or facts or gathering evidence in that place, and you will be drawing inferences from what you observe. The inferences that you draw about your observations and your calculations and your experiments and your demonstrations, all of those inferences that you draw will form the basis for your opinion about what happened. That will be your opinion about a fact or facts. Is your opinion going to be admissible or not? That's what we're going to focus on. So this is a summary from the Evidence Act of the Opinion Rule. It's at section 76. It says evidence of an opinion is not admissible to prove the existence of a fact about the existence of which the opinion was expressed. So that's the rule. Opinions about facts are not admissible. But here is an exception from section 79. This is just an extract from the Act. Again, as I said at the beginning, if you want full text of anything, I'm happy to share things with you. If a person has specialized knowledge based on the person's training, study, or experience, the opinion rule, the rule that I just showed you, does not apply to evidence of an opinion of that person that is wholly or substantially based on that knowledge. So this sentence has been the subject of a huge amount of legal consideration, and this is where most of your work probably will occur. You have an exception to the opinion rule if you have specialized knowledge based on your training, study, or experience, and the opinion that you give is wholly or substantially based on that knowledge. Section 79. All right, so there are lots of terms in here that have been the basis for legal consideration. So what is specialized knowledge? That's important, because specialized knowledge is defined by the discipline, where prescribed forms of training, study, or experience are required before someone can practice in that discipline. So specialized knowledge derived from that discipline is in clear cases usually a matter of peer recognition. So if you say you're a cardiologist, what qualifies you to say that? Well, the discipline of medicine will have its own standards for who can make that claim. What have you studied? What work have you done in the field? Where have you worked? With whom? And so forth. So where a discipline is relatively established, it is clear how we go about establishing the specialized knowledge that you need to have to form the basis of an opinion. But there are some fields of knowledge that are more in the area of emerging knowledge, or maybe areas of knowledge where there is still a lot of controversy about the fundamental principles. And that's where the law gets into a lot of difficulty. So there are three broad questions that need to be answered in determining whether or not an expert witness can testify. Firstly, is there specialized knowledge to be applied to this issue? Because if you don't need a specialist, if anyone can just look at something and go, yes, that is 1 meter long, or that is black in color, you probably don't need to call a specialist. So is there specialised knowledge to be applied? Question one. Secondly, has the expert acquired the knowledge through training, study, or experience? The Act requires you to have one or more of these requirements. So if you acquired the knowledge in some other way, you are not a person with specialised knowledge. Also, the opinion you give needs to be wholly or substantially based on that knowledge. So there needs to be a connection between the specialised knowledge you claim to have and the opinion you give. Essentially, what this is doing is confining the expert to their field. They cannot go beyond their field and give opinions about things that are beyond their own specialised knowledge. So each of these questions I could talk about for an hour, but I won't. I'm just going to talk briefly about the answers to each of these questions, but each of them is a body of a huge amount of jurisprudence. Jurisprudence is the kind of body of legal knowledge, judicial decision-making, case law that's gone into the interpretation of these. So I'll summarise, but I'm happy to take more questions later. Oh, look, I'm going to run out of time anyway. All right. So is there specialised knowledge to be applied to the issue? So as you can imagine, lawyers being not lawyers, the word knowledge has had a huge amount of legal consideration, and the term specialised knowledge has had a huge amount of consideration. There are two different tests. The first two dot points are US Supreme Court cases that give us actually a lot of our principles. The first one, Fry, relates to more traditional fields of science, and it asks questions about validity, reliability, peer review, error rates, the kinds of things that more established and traditional fields of science are able to communicate answers to. Is your field valid? Is it reliable? What is your error rate? What is the peer review process? What is your peer review? What has been your peer review experience? All of those are helpful in traditional fields. Daubert is another US Supreme Court case that deals with more emerging fields of knowledge and says, all right, if there is not a traditional field of knowledge, what other things can we look to decide whether there is any kind of scientific acceptance of what you're proposing to do? So if something is less traditional and less established, there are other approaches to decide if there even is a field of specialised knowledge. The third dot point is a New South Wales case called Tang. This was a field where essentially a person claimed that they were the field of knowledge, they were the entire field, and all of the reliability, validity, standard of the field was what they said it was because they were in a field of one person. This was photographic identification evidence. It led to a huge amount of controversy. Identifying people from photographs has been a huge field of legal controversy. I won't talk about it to this group, but Tang is a case that tried to resolve that field. I don't know that it actually has done so, but it's one of the cases that has tried to intervene where the law doesn't accept what an expert says just because they say it. There is a lot of concern with what lawyers call the white coat effect, where something is dressed up to look like science, doesn't necessarily make it science. So there has been a lot of attention given to deciding what counts as specialised knowledge. So that's the first question. Secondly, has the expert, the person actually in the witness box or proposing to get in the witness box, actually acquired their knowledge through training, study, or experience? Again, a huge amount of law devoted to what each of these terms mean and require, and what you need to do in order to say, okay, I didn't have training, I didn't study it, but I have a huge amount of experience. That makes me an expert. In some disciplines, this is more acceptable than in others. And then thirdly, is the opinion wholly or substantially based on that knowledge? Okay, so this is where the expert is required to say that the opinion they give is based on their expertise and doesn't go beyond that. This is what the court has said is actually a question about the admissibility of the evidence, not the weight of the evidence. So if you can't say that my opinion is connected to my expertise, your evidence will not be admissible. This case of Das Reef, it was a High Court of Australia decision where previously the evidence was admitted and they said, well, just give it less weight because there's this disconnection between the opinion that's expressed and the training of the expert. The High Court has said, no, if the evidence is not connected to the training, it's just not admissible. It's not a matter of the weight given to the evidence. Okay, so jumping ahead, as I said, I wrote about 50 hours worth of content for you. All right, so let's talk about the dialogue between lawyers and scientists, because when I was asked to give this talk, I was asked to address this question. Why do the courts allow the legal profession to vet and select their own experts instead of court-vetted and appointed experts, especially in civil matters? Will this ever change? So this is actually a huge question. It's a subject of a great deal of debate. I'm not going to give you the answer, but I'm going to say some things about it. Firstly, our legal system, as I've said, is adversarial. This means it's a fight between the parties. The courts are extremely reluctant to step into the dispute in any way. Judges at every level see themselves as impartial, and they see themselves as completely separate from, and in fact above, the disputing parties. Anything that looks like the judges are descending into the ring, the barriers to doing that are cultural, ideological, disciplinary, intellectual, and historical. So that is one answer to this big question. But there's another answer, which is actually that for about 15 years in Australia, there have been efforts to change the way that expert evidence is given, and some changes have also happened in other jurisdictions. So the debate in the US was about what they call junk science. But in Australia and in the UK, and also probably in Canada, the problems are less about this idea of junk science and more accurately probably related to perceptions of bias and frustrations about how the legal process doesn't accommodate matters of scientific nuance. The science is not adversarial in the way that the law is, and the terms like proof or probability or doubt probably mean different things to lawyers to what they do to scientists. So there are some moves in some areas to encourage court-appointed experts or joint experts where the parties agree to having the same expert appear, and in some specialist jurisdictions, there have been considerable changes. My understanding is that's happening in the jurisdictions associated with medical practice and healthcare, land and environment, the Dust Diseases Tribunal, but also, I mean, those are very specialised jurisdictions that I don't imagine any of you would practice in, but the New South Wales District Court, for example, in 2016, inaugurated a process for holding what's called a joint conference of experts. It's known as a conclave, and a joint report is produced from this conference. The idea is the experts will determine where they agree, where they disagree, and the reasons for any disagreement. Most commonly, these conferences are facilitated by an independent person who is not connected with the parties and without the parties being present. There are risks associated with the process, and that might be why it's not a well-used process. A lot of parties don't use conclaves because of cost, because of the time, because of uncertainty about the binding nature of the report that will result from the conclave. And also often there are timing issues and how those issues might impact on any settlement negotiations that are going on behind the litigation. Because obviously parties wish to settle out of court, but if you've gone into a conclave, it's not clear to the parties what the impact of the conclave will be on the settlement negotiations that are going on behind the scenes. So all of these procedures that I've just set out in the district court, the conclaves, are governed by what we call, sorry, I missed this slide, the Uniform Civil Procedure Rules. So I'm not going to read through these slides, but I'll just show you that there are rules about these. You can have a copy of these later. I'm just going to show you the headings here because, and the Uniform Civil Procedure Rules also operate in the civil division of the Supreme Court. So these are available in district and Supreme Court matters. This rule says the court may give directions regarding expert witnesses, and that includes some of the things I've just said about the court involving itself in the appointment of experts, the court asking experts to confer with each other, trying to resolve issues, including in things like a conclave outside of court, so that what the courtroom is doing is just resolving the small issues that are areas of disagreement rather than the big issues of an adversarial argument between two different experts. There is a rule that relates specifically to the conference between the expert witnesses. There are rules about the joint reports that can result from those conferences or conclaves. There are rules relating to where parties agree to a single expert being appointed, and that single expert doesn't represent either party, they represent the field of expertise. And there is also a process for the court to appoint experts itself, where it's not the parties who appoint an expert, but the court appoints an expert. All right, so those are some of the answers to the question that I was asked to address, which is what can be done to ameliorate some of the controversies that have arisen where parties bring their different experts into the courtroom and there's a war between the experts. So the conclave or the joint conference is one area. It's available in civil litigation that could ameliorate it. But other ways of doing this are education, like what we're trying to do this evening. There are cross-examination techniques that can be used to better understand the dispute between what the lawyers are trying to find out and what the experts are trying to testify to. It's possible that if there is a dispute between parties, that rebuttal evidence can be called, where a further witness is called to rebut evidence that's already been presented. There are, and I'll show you another slide on this, important ways that experts can express their evidence that would make a huge difference to some of the difficulties we have in courts. Also, there are codes of conduct. There are the duties that experts have to the court. They have to sign an oath or swear an oath or affirmation. And all of those should govern the ethical obligations that everyone has in the courtroom. There are also processes for judges to give warnings about evidence, and there are also processes for the exclusion of evidence. So just on the issue of expression of experts, I'm just going to show you this as an example. And this comes from the discipline of forensic odontology. Forensic odontology is essentially bite mark evidence, because this is an area where the forensic odontologists had their own terminology for what they were doing, and it was misinterpreted by juries. So if you see on the left side, these are terms that forensic odontologists might use. They might use a term like, there is a reliable scientific certainty about something I've done. Or what I've looked at is probable. What I've looked at is consistent with something. What I've looked at is a match. So these are terms that come from the scientific discipline. In the middle column, you will see what the official definition of those terms is. So the reliable scientific certainty is the highest order of certainty in that discipline. There is no reasonable probability of error. So if a forensic odontologist says there is reliable scientific certainty about what I've just said, they are expressing the highest confidence. But jurors interpreted that as being about 70% certain. Whereas the lowest one, match, in the field is described as only having some concordance, some similarity, no expression of specificity is intended. There is a generally similar, but true for a large percentage of population, degree of similarity. So when forensic odontologists say something is a match, they're not intending to express that much confidence, but the juries, the mock jurors in the study, gave that the highest degree of validity or reliability. They gave that an 86% sense of certainty. So this is where there is just bad communication between what the scientists are trying to express and what the fact finder is understanding from that. So a large part of the expert role is to explain or educate the fact finder, not only in the evidence that they're giving, but also in the terminology that they're using. So you might say, I have reliable scientific certainty about what I've just testified to. That is the highest level of confidence I can express in my field of science. So if you do something to translate the level of certainty you have, that is an important part of the role of the expert. So in my remaining time, and I'm sorry I've gone over time, but I can stay longer if you like, I was just going to talk about some recent controversial cases. I say recent, but they're in the last 10 or so years. These are all cases where either the New South Wales Court of Criminal Appeal or the High Court of Australia had to decide whether a scientific expert or a person who'd given expert evidence had done the right or wrong thing. Morgan, Honeysett are both cases about photographic identification. Wood is a case from physics. Wood was, this was a high profile, these are all high profile cases. Wood was convicted of throwing his girlfriend off the gap, and evidence from physicists who had done experimental processes had to decide whether, given where she died and fell, was it more likely that she had jumped or more likely that she had been thrown. Ultimately, all of these cases had their convictions quashed. In the case of Wood, he had an acquittal entered, and Gillam, which I'll finish on because it does involve fire investigation, also had his conviction quashed. And rather than issuing a retrial, he was found not guilty and was acquitted by the appeal court. So Gillam, and there may be people in the audience who are involved in that case, he was accused of murdering his parents and his brother Christopher. So the defendant was Jeffrey Gillam. He was accused of murdering his parents, Mr. and Mrs. Gillam, and his brother Christopher, by stabbing them and setting alight their bodies. His defense was he came home, saw that his brother had stabbed the parents and set them alight, and that he only killed his brother, and that was a manslaughter rather than a murder. So there is a long and complicated procedural history here, but because of the role of fire investigators, I'll just briefly set out the part of the case that's of interest to you. So some of the first responders who arrived were the people who fought the fire, and some of them said they did or did not smell any accelerant on Jeffrey Gillam, because the prosecution case, sorry, to be clear, was that Jeffrey Gillam killed all of these people and set the fire. Gillam's defense was, no, I came home and found that my brother had killed my parents and set the fire, and I then killed my brother. So these are two competing theories of what happened to cause this crime. So there were first responders, some of whom said they did or did not smell an accelerant on Jeffrey Gillam, and whether the accelerant that they smelled was in other areas of the house, and also what accelerant they smelled. There were several experts called, including a fire investigator and doctors who gave evidence about the stab wounds, level of carbon monoxide in the blood of the victims. Essentially, it suggested that the parents were dead before the fire was set. So there's evidence from toxicology, blood spatter, fingerprint analysis, and stab wounds. But of interest to you is that the evidence of a fire demonstration, which was conducted by the Crown expert. So he did some experiments which he filmed to try and recreate the progress of the fire. And it was to contradict the defendant's claim that he wasn't able to assist his parents because of the intensity of the fire. His testimony related to, so the expert's testimony related to the size and speed of the fire. Sorry, this is my layperson's language. I'm sure you have special words for size and speed. But it's important to say that the Court of Criminal Appeal did not question the skill of that fire investigator, primarily those issues related to the DVD of the experiments, which were edited following another legal process, and the jury was shown the DVD. The Court of Criminal Appeal held the probative value of the DVD was very low, and the number of variables and unknowns that the judge had explained to the jury about the experiments might not have been sufficiently clear to the jury. The Court of Criminal Appeal decided that the danger of unfair prejudice to the defendant was still present, even though the judge had tried to explain to the jury the number of variables that were in play, and decided the DVD should have been excluded. They did not define, though, that that was a miscarriage of justice. Also, though, at the Court of Criminal Appeal, the appellant, so that's the defendant, brought forward another fire expert. The Court of Criminal Appeal decided that that person's evidence had been available at the time of the trial, but anyway did not raise any fresh or new evidence that required reconsideration. So the Gillam appeal also concerned all of the other expert evidence from all the other fields that I mentioned. The judgment is 260 pages long. The part about fire investigation is only about 10 pages long, which I can give you the references to. But after 4 years in prison, Gillam's appeal was successful, his convictions were quashed, and a verdict of acquittal was entered. So I think this case and all of these cases highlight the need for prosecutors and defence lawyers, and also all litigating parties in civil proceedings, to be more rigorous in testing the opinions of experts, but also for judges to be more vigilant in applying Section 79 and willing to exclude evidence. But also I think it's important for forensic scientists such as yourselves to arm yourselves with knowledge of the legal process and its limitations, and to help all of us work together to avoid miscarriages of justice, but also to achieve better outcomes under the law. So I'm just going to flick through all of these. The last slide just has my contact details, and I'm happy for anyone to contact me for any details or resources about what I've mentioned today. But also the second last slide just tells you where in the Gillam judgment to go, which were the grounds that related to the fire investigators, if you're interested in reading more about that. So I'm going to stop my screen share now and take any questions or comments or any discussion or any feedback, or if anyone wants to tell me about one of their experiences, I'd love to hear it. So thank you, and sorry for talking so long.
That's great. No, it's really, really good. Thanks, Catherine. I've got a couple of questions. I know there's a couple coming up in the chat there. I guess for this forum, we find ourselves quite often going into court against another fire investigator, and a lot of the time they're saying absolutely opposite what you're saying. Now, they're obviously being paid by the defence, and you've got this battle of experts. I guess from your perspective as a legal scholar, what should fire investigators be doing to, and you've probably answered this already, but I'd like you to sort of, I guess, sort of specify, what should they be doing to make sure that their opinions are as good as they can be, and making sure that their opinions are heard in what they're doing?
Yeah, look, it's a great question, and it's a hard question, because as I've said, this is an adversarial process, and as you've rightly identified, the different experts are paid by the different parties. But as I didn't say, but perhaps should have, is that the experts owe their duty to the court. They don't owe a duty to the parties. So just because someone is paying you doesn't mean you need to give evidence that absolutely supports that party's theory of how this crime or this civil action arose. So it's important that everyone understands that. It's actually contempt of court to breach your duty to the court and go beyond the evidence only because you're supporting your party. But I think it's also important, and this is what I meant earlier, I mean, the law has really clunky processes like the cross-examination process or the re-examination process, probably not the best process for really testing where you agree and where you disagree. But it's important, I think, for experts to translate their knowledge for the fact finder, for the judge or the jury, and say, look, I heard the expert from the other side. I agree with this. I agree with that. I have no dispute about this. On this issue, nothing turns. If you could narrow what's in dispute and go, the main thing we disagree with is this. And this is why there can be a reasonable disagreement between two experts on this kind of matter. And it may be it's difficult to replicate experimentally, or we don't have enough knowledge to know, certain facts from which our experiments were conducted, or there is some disagreement amongst experts on what is the best way to test this hypothesis. So just explain, firstly, where is the actual dispute? Narrow what's in dispute, because it may be that there are things with the other expert that you do agree with and that there's no controversy about, and you should say that. Agreeing with some of what the other expert says is not weakening one party's case, it's narrowing what's in dispute and saying this is what's in dispute and this is why there is a dispute, and explain maybe there's a good reason why people with the same expertise can come to a different opinion with the same data. It doesn't mean one of you is right and one of you is wrong. There may be reasonable disagreement. Yeah. So I think a lot of the role is also just explaining and translating for people who know nothing about what you know, what you disagree with and why it might be there's a disagreement, and why you might think this is a better interpretation or a weaker interpretation. But to the extent that there is uncertainty, you should express where there is uncertainty and don't go beyond your own uncertainty.
Yeah. And what a follow-up to that is that a lot of investigators that I know and work with as well see a certain few investigators out there that we would say that they would just say, whoever's paying the bill, I'll just do their opinion. Whatever they want me to say, they will say. And the frustration is that no matter what we come up with or what our opinion is, it's always going to be opposite to that. But I know that you're saying the duty is to the court, but I guess I don't think I've ever heard of someone who has been sort of not convicted or held in contempt of court for not doing that, for not being an advocate for the court or working for the court. They will, because the other side is paying the bill, the defence is paying the bill, they're going to stick with that opinion, and they know, well, that it's wrong, but that's their opinion for opinion's sake. I mean, I know it's a rhetoric question, but it's just very frustrating from a lot.
I understand that, and every discipline has those experts.
Yeah,
it's
true.
not just in fire investigation. And so, I mean, to the extent that it's possible, you can communicate with counsel that you are advising. I've been up against this person numerous times. They only ever act for the Crown. They only ever act on this side, and they can actually put a question like that to that witness.
Yeah.
Have you ever acted for a defendant? Have you ever had a conviction overturned on appeal because of the evidence you've given? So, you can arm your own, because it's possible that the counsel that you're giving advice to may not have been up against that expert. So you can do some of that.
I find the prosecutors are reluctant to question them about their history and their knowledge and stuff like that, where in the US, you're seeing that a lot. You're seeing certain fire investigators struck out and saying, no, you're not giving evidence in my court because of you haven't demonstrated enough, A, B, C, and D. Whereas I think the prosecutors here and the judges here just, let everyone give an opinion and, let the jury or the judge decide who they're going to believe. That's a bit frustrating as well. Another question I have is that a lot of fire investigators, they should be using the scientific method to develop their hypotheses, test their hypotheses, and then select the final hypotheses. A lot of that testing, or some of that testing, sometimes involves actually recreating fires and taking those fires and trying to sort of burn and observe and learn from what has happened and from a certain incident sometimes. And that's, I guess, in the Gillam case, where it gets again frustrating, and it's happened to me once, where I did it for the coronial inquest into a death, and that was accepted, the evidence. And I wrote a statement around that, an opinion, and that went to the coroner, but then the coroner shut it down and sent it to the criminal, DPP, and then they charged, a murder charge from it. And then from there, just before the trial started, a week before the trial, the prosecution says we can't use that evidence because of Wood, and say that, we do all this testing, we don't know where it's going to go. We do, and we come up with that opinion, but then we're not allowed to use that opinion in court because it's, I guess it's because of the Wood trial or whatever. But my rebuttal was to say, hang on, I'm a fire investigator. I'm testing fires. I'm doing fires. That's my expertise. Wood was, I think, is more, he was outside his lane of expertise and gave evidence. That's why it was appealed and won the appeal. So it's very frustrating to see you put so much work into sort of these hypotheses that you're developing, and then they're not used. But then, the defence can use them, but you can't. So, it was a frustrating case for me, that was.
Yeah, look, that's all really important. I think from the way you've described it, it seems like someone has misunderstood Wood, but also because when the superior courts hand down these decisions, they tend to intimidate other judges and counsel into thinking that the case stands for a much bigger principle than it did. I mean, the physicist in Wood, partly what he didn't disclose was that he was writing a book about it. He was trying to profit from that. He also didn't disclose, so his experiment said he took men of roughly Gordon Wood's strength to pick up women who were roughly the size of the deceased, to spear throw them into a swimming pool and see how far a guy of this strength can throw a woman of this stature. and figured out that, yes, it was possible that you could spear throw a person off the gap in Watson's Bay, and that's where the body would end up. What he didn't disclose was that would only work if the victim was not offering any resistance at all. And, you know, you could imagine that it would be much more difficult to spear throw a person who's resisting than a person who's not resisting. But all of the experiments were done with a completely compliant volunteer. So by not disclosing that, that did significantly undermine his conclusion that she was thrown rather than that she jumped. So I think that's quite a different limitation on the evidence he gave to what you've described about your own evidence.
Yeah. And the problems with our recreations as well, it's very rare that you're going to get exactly the same conditions to recreate. And fire is such a difficult thing to replicate as well, because there's always something different. And what burns in one room, you know, is going to be different to what burns in the same room under different conditions, whether it's, you know, just the temperature or the fuel load and things like that. So it's very difficult to replicate. Anyway, enough about me, my questions. There are a few that have come up. Angus is asking, with exception to our lack of knowledge in legal processes until now, be it in criminal, civil or criminal environment, what are some of the pitfalls you see expert witnesses fall into? I guess what is that not to do or don't do's, or I think that's what he might be asking. Maybe, Angus, you want to come on online on your voice there, Angus? And
yeah, no, you nailed it, Mick. It's
right.
What mistakes do you see them make in the box?
There you go. Yep.
Yeah, look, I think I could talk for hours about this, but I won't. I think this also arises from something Michael said, because there is such a big cultural difference between the adversarial legal process. So when you are cross-examined by a barrister, that probably doesn't happen to you in most other aspects of your professional life, given what you do in your professional life. And I think a lot of experts find that hostile and challenging, and think that their own professionalism is being criticised, and think that they are being told that they are wrong or stupid or not being respected, when they are probably entitled to believe that they are a highly respected and very distinguished member of their profession. So I think sometimes experts think that the cross-examination technique is a personal hostile attack, and they arc up a little bit, and then they perform in a way that is seen to be defensive or self-serving, rather than just staying calm, staying focused, explaining, this is my method, this is what I did, this is why it's valid, this is why it's reliable, these are the areas of uncertainty, this is my degree of confidence, and not feel like the techniques of cross-examination are a barrister who's probably never heard of fire investigation before yesterday, trying to attack someone who's got decades of experience in a field. It's not personal, but it is a technique that some people find confronting, unfamiliar, challenging, and sometimes experts perform in a way that ultimately undermines what is the true purpose of their role, which is to translate for lay people what you know and what you've done.
I do find also that practice makes perfect. So the more you do it, you get better at it. But unfortunately, there's always going to be that first time for someone. You got to go in there, and you just got to hopefully do your best. And yeah, you're going to be put under pressure and made to look like an idiot. That's just part of giving evidence. I find it when my fire investigators that I'm teaching and they go to court for the first time, I try and do a mock court for them and throw questions at them and put them under pressure and see how they go. Not comfortable, but yeah, it can help you when you're actually doing it. Peter Nixon says, does case law have any effect on expert evidence?
Yes. So all of the cases I mentioned at the end are just 4 out of hundreds of cases, which have all slightly or significantly changed the way expert evidence can be given. So for example, just very briefly, I mentioned identifying people from photographs. It used to be the case that, let's say there's a surveillance camera in a crime scene, all of the images would be developed, they'd be passed around local police stations, police would flick through the images or look at the video and go, I recognise him, I recognise her. Police would get in the box and testify, I know Michael Forbes, I've arrested him on 3 occasions, I've spoken to him on 5 occasions, I look at this surveillance photo, that is Michael Forbes robbing the bank. Sorry, Michael, that's just an example of using your name. And that used to be how identification evidence was given. I know this person, I look at the image, I recognise. There was a High Court case called Smith that said police can't do that anymore. So they went, okay, what can we do? Let's call experts. They're like, well, who's an expert in identifying people from photographs? Well, no one. That's not a field of forensic science. A bunch of people put themselves forward and said, well, I'm an anatomist. I know a lot about human bodies. I'm just going to do anatomy in a photograph. Or I'm an anthropologist. I know a lot about human remains. I'm going to do that with living people in a photograph. I'm a military imaging specialist. All these people came out of the woodwork and said, I have some other expertise. I can identify people from photographs. For a long time, that was the response to the High Court case in Smith, which said police can't do it. Now experts can do it. But the case of Tang, which I referred to earlier in a slide, and the cases of Honeysett and Morgan on one of the last slides just went, no, no, no. You can't just say I'm an expert and be an expert. That's where I got the term the white coat effect. Just because you say you're an expert in something doesn't make you an expert in everything that you say you're an expert in. So the case law is important, and the case law significantly transforms what counts as expertise and who can be an expert and how an expert can express their opinions. Very important.
Yeah. Yeah, thanks for that. Darren's asked, what weight is given to academic qualifications versus years of real world experience and knowledge? And that's a common theme. Hard to answer, but I'll leave it with you.
Yeah, so when you are asked to prepare an expert report, so the way it works is you would first be asked to prepare an expert report. You may or may not, after that, be called to testify to your report. But when you do write your expert report, you also tender your CV, and that would include your education, your training, any other skills you've obtained, but also your expertise and experience and anything else you've done that qualifies you to claim to be an expert. There is no formal weighting given to any of those things.
Okay.
You may have a PhD in it, but never left your office. And you may have a TAFE certificate in it, but have a huge, many years of experience that is hugely valuable. I wouldn't say the court would say that the PhD is more valuable than the other or vice versa. Your CV goes into the expert report and it really ends up being either a battle of the experts or just a testing of what you can and cannot know or say. There's not a formal weighting.
Yeah, I agree. There's no other questions here, but I do have another one. I don't know if you're aware of this, but in the US, the OSAC, which is the Organisation of Scientific Area for Committees for Forensic Science, have produced a report around fire investigation and the way forward for fire investigation and what it should be doing in terms of how an investigator should be, I guess, preparing themselves to the field. In other words, getting him or herself educated and being able to give testimony and stuff like that. Do you see that as the future in terms of, do you think that will happen in Australia where there is a, I wouldn't say a shake-up, but like a review? I know there was one in Melbourne that was done before the pandemic, and I think it's been postponed or something about what forensic science is happening in this country and how, I guess, what are they going to, do you expect any changes, I guess, in the future of what's happening in this field where, you know, we're giving opinions on the type of work we're doing, which in the US, they're saying now we're more science-based industry or science-based work. Do you see the future being, you know, you've got to prepare yourself to have that sort of in your background or in your resume to be able to give these opinions?
Whether I see that happening in Australia, I doubt, but I would love that to happen in Australia. What's happened in the US, and thank you for, I didn't know that there was new kind of standards for fire investigators, but what happened in the US was driven by the National Academy of Sciences. So it was driven by their scientific peak body. That does not happen in Australia. The scientific peak bodies are not driving this debate. This debate is being controlled by chief judges and other legal professionals. And that is, I think, a huge problem. The reason I started with Lindy Chamberlain is because the Chamberlain Royal Commission and wrongful conviction led to a massive transformation in forensic science in Australia. Huge investment in forensic science, technique, expertise, training, qualifications, And it would be a shame if all of that great work was lost because we are allowing lawyers rather than scientists to drive this. We do need peak scientific bodies to drive this. Otherwise, we're going to end up continuing with what you've described, just a battle of the experts paid by their different adversarial parties. And we're not going to end up learning more about scientific answers to questions. We're going to learn who had the slicker expert. And that's not what anyone wants from litigation. Litigating parties don't want that. They want to get the right outcome. So whilst I would wish that that is the future in Australia, I'm not confident to say that it's happening now. Some areas, DNA, for example, they are much more advanced and organised than most of the other scientific techniques. There are some techniques more than others that seem to be a little bit more regulated or ready to operate collectively. But if you're in a discipline where people are prepared to stand up and argue against each other, I think that's where you're going to continue to get the problems you've described.
Yeah, thank you. I know, and hopefully, as you said at the start here, people that are doing extra and doing as much as they can to, build up their knowledge base, such as listening to a debate like this, sort of are doing better things for themselves, so that when they do come to giving evidence, that they're best prepared and hopefully giving a better opinion as best they can. There are no more questions. We have gone over time, but it's been great. Unless anyone else has anything from the floor, they can unmute themselves and throw a question at Catherine. Last chance. There's plenty of thank yous there. Listen, I think we will end it at that. Thank you, Catherine. I've seen you speak now twice, and they're both enthralling times. It's really an important part of what we do is that legal aspect and legal proceedings. And the more advice we can get from people such as yourself, hopefully everyone gets something out of it. So I do thank you. Thank you, everyone, for coming on board. This will be posted on our YouTube site as a recording in the next couple of weeks. We're having another education night in June. We're looking at drone technology and where that's going and its good use and uses for fire investigation. Again, thank you, Professor Catherine Biber, for being our guest tonight. I think Mark did a great job in securing you and getting all the information done, and he may even be sending you a gift, I believe. That's normally we do this face-to-face when we give you something. It's very hard over Zoom, but thank you for your time, and thanks again.
It was my pleasure. It was lovely to talk to you all, and I learned a lot from it myself. So I appreciate your time. Have a great evening. Thanks, everyone.
Thank you, everyone. Thanks, Bobby.
Thanks, Catherine. Thanks, everyone.